is being imposed because you abused 26 children.
Mr. Esco, you struck the victim in this case 127 times.
He has verbally, emotionally, and physically, or sexually, however you want to put it, assaulted me in my own home.
Yonkers police labeled the attack on a 67-year-old Filipino woman as the worst hate crime in the city in 25 years. The assault was carried out by 42-year-old Tammel Esco, who remained silent in court during his sentencing.
Mr. Esco, you struck the victim in this case 127 times.
The judge spoke of the nature of the attack, which occurred as the woman was returning to her Yonkers apartment building. The incident, too graphic to be shown on TV, began with an anti-Asian slur and ended with assault.
When it was done, how exhausted you were. You could see that you were breathing heavily.
The victim described how a stranger assaulted her just because of her heritage. The victim shared that the attack had stolen months from her life, and she would forever be on edge. The fear of the assault forced her to move out of her longtime home on Riverdale Avenue.
Leaving the home that you've had for 24 years and where you raise your daughters is incredibly painful.
This hate crime wasn't the first time Tammel Esco had been caught on video committing violence against a woman. In February 2021, Esco was recorded pushing a woman through a window. Although the woman wasn't seriously injured, Esco was sentenced to substance abuse treatment. In court, the judge mentioned Esco's troubled past, including growing up in foster care and struggling with mental health and drug issues. When given the opportunity to apologize or explain, Esco declined.
The Yonkers hate crime was not the first time Tammel Esco committed an act of violence against a woman caught on camera.
Tammel Esco was sentenced to 17.5 years in prison, which was part of a plea deal after he pleaded guilty to the attack on the 67-year-old Filipino woman. Esco will remain behind bars at least until the year 2039. In May 2021, Angela Montgomery, a 23-year-old woman from Rincon, Georgia, was charged with shooting 23-year-old Gabrielle Rogers and kidnapping her twin sons, Matto and Lorenzo. She was denied bond in the court after detectives revealed new details about the case.
Miss Montgomery, your bond is denied.
The detectives shared more information about the shooting and the kidnapping of the twins, including how Montgomery met the victim.
It looked like she had been meeting with Facebook on New Mothers. She had set up this meeting. This had been planned.
The incident occurred after Montgomery met Rogers through social media. On May 11th, 2021, Montgomery arrived at Rogers' home, where she shot Rogers, leaving her critically injured, and abducted the twins. Rogers survived the attack and was hospitalized. The twins were found unharmed at Montgomery's residence in Rincon later that day.
Miss Montgomery was in a closet. The victim had been shot with a .40 caliber pistol. In the closet with her was a .40 caliber pistol.
Once Montgomery was arrested, detectives said she agreed to speak with them in an interview.
She said she was unaware of the crime, that she was assisting her twin sister, which she does not have, and that she took possession of the children from this twin sister and then tried to pass them off as her own children.
At the end of the court hearing, Montgomery's attorney requested that she undergo a mental health evaluation.
So that's going to be part of the follow-up, trying to understand, not just what happened, but why it happened, how it unfolded.
In November 2023, Montgomery pleaded guilty but mentally ill to charges including criminal attempt to commit murder, 2 counts of kidnapping, and aggravated assault. She was sentenced to 30 years in prison with life probation. Elias Acevedo, a man suspected of being a killer and rapist, stood before a judge. In the courtroom, he pleaded not guilty to the murders of Christina Atkins and Pamela Pemberton during initial trials. He was arraigned on nearly 300 charges, and the bond was set at $5 million. Prosecutors requested this amount, asking for $1 million for each of the 5 victims mentioned in the indictment. During the hearing, Acevedo remained calm and focused, only speaking when the judge inquired if he had enough money to hire a lawyer. His response was simply, "No, sir." Prosecutors indicted the 49-year-old man from Cleveland for the cold case murders of Christina Atkins in 1995 and Pamela Pemberton, whose life was taken in 1994. Acevedo's crimes were uncovered after the FBI revisited the disappearances of women in the Seymour Avenue neighborhood, where he lived near Ariel Castro. This investigation led to his indictment on multiple charges, including aggravated murder, rape, and kidnapping. In the courtroom, Atkins' mother and relatives sat quietly in the back. They chose not to speak with the public afterward.
Law enforcement is requesting the assistance of the public in the investigation of Elias Acevedo. Anyone with knowledge regarding Mr. Acevedo or any other crimes that he may have committed is invited and asked to call the FBI at 522-1400. That's 216-522-1400.
Finally, he pleaded guilty to 297 counts, including the murders of Christina Atkins and Pamela Pemberton and the sexual assault of his sister-in-law, his 3 daughters, and 2 other individuals in 1993. In December 2013, he received 2 consecutive 20-year to life sentences, along with an additional 405 years for rape and other charges, with no possibility of parole. Caitlin Nelson, a former daycare center worker, was on the run for more than 5 months before being caught and locked up in the El Paso County Jail. 2 of her co-workers were already serving time in state prison after being convicted of multiple child abuse charges. These charges came after they were found hiding boys and girls behind a basement wall. Nelson was missing after failing to show up for her jury trial. She faced 28 different charges, most for child abuse and some for drug possession.
I think that we all are very happy with the outcome.
It had been an emotional day in August when parents learned that 2 women, including Nelson's co-workers, had been found guilty on more than 50 charges, most of them related to child abuse. The parents were the ones who had trusted a daycare named Play Mountain Place to care for their daughters and sons. Carla Faith, the woman who ran the daycare, was only licensed to care for 6 and wasn't cleared to have employees. After refusing surprise daycare inspections, state officials performed a welfare check. They arrived just as one of the boys and girls was being picked up and soon discovered 25 hidden behind a false wall in the basement. Faith and her 3 employees faced child abuse charges.
The sentence in this case is being imposed because you abused 26 children. Let's be clear, Ms. Faith. What you did was wrong on so many levels.
But Nelson remained on the run until she was arrested on unrelated drug charges less than 2 weeks ago. At the time of her arrest, police had 4 warrants out for her. In addition to the child abuse charges, she faces 2 additional drug charges after police reportedly found syringes and meth at the daycare. In July 2022, Nelson pleaded guilty to 1 count of possession of a controlled substance and 26 counts of child abuse. She was sentenced to 1 year in jail, with 4 years of supervised probation upon release. Nelson's co-defendants, daycare owner Carla Faith and employee Christina Swager, were also convicted and received sentences of 6 years and 2.5 years in prison, respectively. In May 2020, the family of an 86-year-old woman, Pearl Connor, expressed relief when the caregiver who severely injured her was finally sentenced to prison. Shelia Knight, the caregiver, had gone on the run right before a jury found her guilty 2 months ago. The family said this sentence brought them peace, knowing their loved one could finally rest. They walked out of the Cobb County Courthouse, waving the guilty verdict and sentence documents, feeling they had proof that Knight was receiving the punishment she deserved.
It's been 3 years of just dealing with the trauma of it.
Pearl Connor's family members testified in court, stating that Shelia Knight had taken away their family's jewels.
I pray for her. She really does have a problem.
The family explained that Knight's disappearance before the jury convicted her of aggravated battery and elder abuse only prolonged their search for justice.
We have waited for this day for so long.
The incident occurred in 2019 when prosecutors said Shelia Knight, a caregiver, pushed Pearl Connor down inside her home. Connor's family had installed cameras, and when they reviewed the footage, they saw the incident. As a result, Connor died a month later, in March 2020. Knight remained a fugitive for 8 days before a fugitive team captured her. During the sentencing in May 2020, Connor's family asked the court for the maximum sentence of 20 years.
So she will understand what she did was wrong.
But Knight maintained her innocence, telling the court that she did nothing wrong and claimed that Connor had attacked her.
When she attacked me, I got scared. The video had been altered.
That was her last-ditch effort, but we knew what the truth was.
The judge disagreed with Knight's defense, sentencing her to 20 years in prison without parole. Connor's family was deeply bothered by Knight attempting to blame their loved one for the incident. The family planned to visit Connor's grave to inform her that justice had been served. Marie Collins, a 34-year-old woman from Raymond, New Hampshire, appeared in court to face her 4th DWI charge, only receiving a fine from the judge.
She's accepted responsibility for every single offense.
She faced multiple driving while intoxicated charges between September 2019 and January 2020. She was arrested 5 times within this period, with her most recent arrest occurring on January 6, 2020 in Danbury. Due to the processing times in the court system, each of Collins's offenses was considered a first-time offense, resulting in lower penalties.
By operation of the law, you can't be charged with a second unless you're convicted with a first.
For her first 2 offenses, she received fines and was released. Subsequently, she was sentenced to 33 days in jail for violating bail conditions from one of her earlier offenses and an additional 5 days for pleading guilty to an aggravated DWI.
It was important to me that she serve a separate penalty for breaching the terms of her bail and have a penalty for the DUI.
Collins was set to be released. Prosecutors mentioned she would be certified as a habitual offender and her license would be revoked for several years. However, her family believed this might not stop her from getting behind the wheel again.
She had the first 2 or 3 DUIs, went to Florida for 2 months for rehab, came back and reoffended in Danbury on an aggravated DUI again.
Collins' mother-in-law felt that more needed to be done to make the roads safer.
She's proved that the process is not working for her yet. I hope that it does, but it isn't yet.
In February 2020, Collins pleaded guilty to 3 DWI charges and 1 reckless operation charge, which was reduced from a DWI charge. She also faced another DWI charge that was still pending at that time. Collins was held in preventive detention during her video arraignment on a breach of bail charge filed by New Hampshire State Police. Her license was suspended, but she allegedly continued to drive after judges in each DWI case allowed her to be released on bail. In April 2021, Fresno residents Xiong and Joshua Yang faced felony charges of child endangerment after their daughters and sons were found alone in their apartment under concerning conditions. Upon entering, a passerby discovered a boy unattended outside the home and found the other 3 inside. The apartment was reported to be in poor condition and lacking food. Both parents were arrested. Joshua Yang was taken into custody at the scene, while Xiong turned herself in to the Fresno Police Department later that day. During their court appearance, both entered not guilty pleas, and their defense requested pretrial release, citing their lack of prior criminal history. Yang's older brother, Jason Yang, spoke out about the case. He stated that there were no signs of neglect, and that his brother was a hard-working father who loved his daughters and sons. Both the prosecution and Jason Yang pointed out questionable behavior from the mother, Xiong. However, both parents faced the same charges. Xiong and Joshua Yang waived their arraignments, which meant they entered an initial plea of not guilty. Their defense also asked the judge for a pre-trial release, arguing that neither of them had a criminal history. Jason Yang, in a statement sent through social media, said that his nieces and nephews had never been malnourished or shown any signs of living in poor conditions.
Mr. Yang works full-time. Him being in custody would affect his ability to produce an income.
He added that his family knew Xiong had flipped mattresses, dressers, and the crib until his brother gave in and let her leave to gamble. The prosecution claimed that Xiong left to play cards the night before she and Yang were arrested.
Xiong, the mother of these children, advised that she was going to go play poker the night before and that she'd be home by 7:30 in the morning. So he leaves to go to work that day thinking that she's going to come back and watch the kids.
Referring to the police report, the prosecution said Xiong told her daughters, sons, and an arriving officer that she had gone to the 500 Club in Clovis. Initially, both parents' bails were set at $100,000, but the judge later reduced them to $25,000 each. A pre-trial was scheduled. In June 2015, Douglas Alan Mehan, a resident of Great Falls, Montana, was charged with the rape of an unconscious woman in the parking lot of the Sidetrack Lounge. Court documents revealed that surveillance video showed Mehan handing a woman a drink at a bar, and after 3 drinks, she became visibly drunk. The video also showed Mehan walking the woman outside to his truck, where the assault occurred. Judge John A. Kutzman expressed that the video was especially disturbing to him.
The joint plea recommendation in this case is 50 years at the Montana State Prison with 25 years suspended. It's been repeatedly depicted today as quotes, harsh quotes by both sides. I really don't think it's that harsh, given what happened here. I question, frankly, whether it's harsh enough.
In deciding the sentence, Judge Kutzman followed the binding plea agreement. This decision was made to spare the victim from any further public exposure that might have come if the case had gone to trial. Mehan received a sentence of 50 years in the Montana State Prison, with 25 of those years suspended. Camille Knox, a woman from Massachusetts, was denied bail after being involved in a robbery and hostage situation.
She remained preventatively detained pending trial.
Authorities reported that on August 1st, after robbing an Exxon gas station in Hampstead, Knox drove her fiancé, Jose Robles, away from the scene. The couple then broke into a home on Wellington Drive, where they held a family hostage and demanded money.
She brings a black bag, which money was falling out of the bag.
Officers said the family told Knox and Robles they didn't have any money, so the couple decided to force the victims to take them to an ATM.
The girls in the family would drive with Miss Knox, and the males in the family would drive with Mr. Robles.
Before they could leave, police arrived, causing Knox and Robles to retreat back into the house with the family. During this time, Robles handed Knox what turned out to be a BB gun. The defense argued that Knox used the gun to protect the family, but the officer's testimony contradicted this claim.
When Robles handed her the gun, instead of protecting the family like she was claiming to, she held it at the mother's side.
The judge decided that if Knox had no intention of participating in the crime, she would have acted differently.
The conduct that I heard evidence of doesn't support the defense contention that she was just there involuntarily along for the ride.
The judge further stated that by aligning herself with a dangerous person like Robles, Knox became dangerous as well. In January 2024, both Knox and Robles pleaded guilty to all charges, including armed robbery, kidnapping, and criminal threatening. Robles was sentenced to 25 to 50 years in prison, while Knox received a sentence of 3 to 6 years. The judge noted that Robles was particularly dangerous when not of stable mind, agreeing with the prosecution's sentencing request due to his past violent convictions. A former detention officer, Carmen Bailey, from Fulton County, found herself in jail accused of accepting $177,000 in bribes to smuggle contraband into the jail. When investigators examined her iPhone, they discovered financial transactions linking her to Marquavius Huey's family, among others. Investigators believe that 4 other inmates were involved in this criminal scheme as well.
I was like, wow, I was shocked.
Deputy Tessa Cole described her reaction when she saw the jail security footage in July during a criminal investigation into the former officer. The investigation revealed that the officer, Carmen Bailey, had taken $17,000 in bribes to help inmates smuggle in drugs and cell phones for sale inside the jail.
There were specific transactions on certain days that aligned with nefarious and criminal activity going on her floor by her.
The investigation into Bailey started when 2 inmates came forward, accusing her of criminal activity. In the security video, Bailey escorted 2 inmates into a restricted jail area. One of the inmates had his identity blurred due to cooperation with the investigation, while the other, Marquavius Huey, was one of 6 defendants in the YSL Rico gang case. Court documents said that Huey's family, including his mother and brother, paid Bailey $1,500 to help him sell contraband to other inmates. Bailey was also accused of working with at least 4 other inmates, including Osama Emanuel and Marcus Foley, who are awaiting trial on gang and murder charges.
We've started to really implement a lot of data to track, obviously patterns, and in this tracking, the amount of contraband found on the floor that she was operating and, had a duty post orders, it was an uptick.
The attorneys for Marquavius Huey issued a statement addressing the allegations of corruption and bribery. They emphasized that Huey, who has been in custody since December 2021, is presumed innocent until proven guilty. Regarding the YSL RICO trial, Marquavius Huey accepted a plea deal on October 30th, 2024, pleading guilty to charges including racketeering, conspiracy, and robbery. He was sentenced to 25 years, with 9 years to be served in prison, 11 on probation, and 5 years suspended. Furthermore, both Huey's mother and sister have also been arrested on bribery charges, according to jail records. Todd Jameson, 27, faced harsh words from a Kent County judge after admitting to using racial slurs targeting predominantly black churches and funeral homes in Grand Rapids.
35 years, and if I had to give a profile of who would be a mass murderer, that would be you right now.
Jameson had left the offensive remarks in a voicemail and an email. During his sentencing in a Grand Rapids courtroom, Jameson apologized for his actions, though he argued that it was rude for the judge to call it racist. Despite his apology, the judge decided to send him to prison.
You, sir, are clearly a racist, and there is no excuse for that.
Police confirmed that Jameson was responsible for making racially charged phone calls and sending emails to Brown's funeral home and Brown Hutcherson Ministries, both located on Jefferson Avenue Southeast.
And you made outrageous racial slurs to the point where I couldn't even repeat them in this courtroom. You threatened these people. You talked about exterminating them.
Hollywood, who received one of the phone calls, spoke about her lasting fear. The threats still make her look over her shoulder, and she feels afraid.
The temperature of the world today and all the violence going on is just unacceptable.
Jameson acknowledged that his actions had been rude and unkind.
Did not think about the climate of the world and how, things are happening, with insults and all the bad, the shootings and whatnot.
In late May, Jameson pleaded guilty to ethnic intimidation. The judge noted that Jameson had prior convictions, including assault and disrespectful behavior, and had several run-ins with the police.
If I had to give a profile of who would be a mass murderer, that would be you right now.
Ethnic intimidation carries a sentence of up to 2 years, with sentencing guidelines suggesting a term of 0 to 9 months. However, Judge Mark Trusock decided that Jameson's actions and behavior deserved a harsher sentence.
You're very lucky you're not looking at a 10 or 15 year maximum, because you'd be going to prison a lot longer than you will be today, sir. Take him to prison. I hope you think every day while you're in prison about what you said and did.
As a result, Trusock sentenced Jameson to between 16 months and 2 years in prison. On top of his prison sentence, the judge imposed a $5,000 fine. Ryan Kupres, a father convicted of child abuse, faced strong words from an Ottawa County judge. The judge called his actions despicable and beyond outrageous after Kupres was convicted of shaking his daughter. The victim, Kupres' daughter Layla, was in serious condition for a few days after the incident, but she eventually recovered and did not appear to have any lasting effects. This wasn't the first time Kupres had been accused of child abuse. In 2008, he pleaded no contest to abusing his son, who also sustained broken bones.
The jury got this case absolutely right. The court finds that words cannot adequately describe the crime that you have committed against your children. Your repeated acts are beyond despicable, beyond reprehensible, and beyond outrageous. Because of that, the maximum sentence is not only justified, it is demanded in order to protect your children and society as a whole.
The judge stated in court that it was clear Kupres had enjoyed causing pain to his own daughter and son. As a result, the judge sentenced him to spend between 180 and 270 months in prison, which is roughly 15 to 22 years. The sentence was harsher than the sentencing guidelines, as the judge believed Kupres deserved more time due to the severity of his actions. Ronald George, a promising 19-year-old with dreams of college and football, faced a life-changing series of events on August 26, 2016. Despite being raised in a supportive family and taught values of respect and responsibility, George made a decision that led to severe consequences. On that night, George and an accomplice entered a home intending to commit theft. During the incident, George used intimidation to take items, including money and personal belongings. The situation left the victim deeply shaken, creating lasting emotional distress.
This man made a conscious decision to commit these crimes. He chose to ruin whatever he had going for himself. I did not get a choice, however. Ever since that night, I have felt dead inside my own skin. This man, on the night of August 26, 2016, came with a gun and his friend to my house. This man robbed me at gunpoint over money, a speaker, and weed. It may not sound like much to some, but I was robbed of a lot more things that night. I am the one who is suffering. I am the one who is in pain. I am the one who doesn't feel safe in my own home. I am the one who always has to look over my shoulder. I am the one who can no longer trust anyone. I am the one who was assaulted. I am the one who is lucky to be able to give this statement. My head and demanded I take off my shirt. I refused. He said something that plays like a broken record in my head, and excuse my language. He said, "Take off your shirt or I'll blow your f***ing brains out." I continued to refuse because honestly at that point I would have rather been dead. That night this man robbed me of everything besides living. My life was in the palm of this man's hand. I am a victim of this man's choices every day for the past 8 months. I have been living in a hell. I no longer think life is about living. Life is about surviving. Nothing can ever erase this from my mind. I can't change what has happened to me, but I can possibly make an impact on it not happening to someone else.
The victim later shared how the event had turned her life upside down. She described feelings of fear and insecurity that lingered long after the incident. Unable to feel safe at home or in public, she began attending weekly counseling sessions to cope with the trauma. The experience affected her ability to work, maintain friendships, and enjoy a sense of normalcy. Her powerful statement during the court proceedings highlighted the profound and lasting impact the event had on her daily life.
He has verbally, emotionally, and physically, or sexually, however you want to put it, assaulted me in my own home. I go to counseling once a week ever since this. I don't feel safe. I'm fearful of being out of my home or in my home.
How long have you been going to counseling?
Probably around 7 months now. I haven't been able to keep a job since then. I have lost friends due to this. I can't sleep. I'm paranoid all the time. I can go on and list things upon things upon things that have changed in my everyday life because of this man.
During the legal process, George addressed the court, expressing deep regret for his actions. He acknowledged the harm he caused and apologized to the victim, his family, and others who believed in him.
My name is Ronald George. I'm 19 years old, and last summer I made a terrible choice that will impact my family, a young woman, and several others for the rest of their lives. I have no excuses because I knew better. My mother and father raised me to be respectful, religious, and responsible. On August 26, 2016, I was none of those. I came to Kalamazoo to get an education and fulfill a lifelong dream to play college football. Neither of those will ever happen again. And for that, I have no one to blame but myself. The list of people I'd like to apologize to is long. From my mother and father, to my friends and extended family, to my mentors and coaches who believed in me that I let down. But most importantly, I'd like to apologize to the young lady who my actions made fear for her life. For that, I'm truly sorry. Every day I wake up, I have to live with the impulsive decision I made. Not only does it affect me, but the people I love. I feel regretful and ashamed for my horrible behavior. And prior to enrolling to Western Michigan, I attended Central Catholic in Pittsburgh, Pennsylvania. The mission of Pittsburgh Central Catholic is to inspire boys to become men of faith, scholarship, and service. For 4 years, I lived those values. For one night, on August 26th, I abandoned them. One bad decision has changed the course of not only my life, but several others. My dreams of college education at Western Michigan and the privilege of playing college football are gone. My hopes of being a role model to my younger family members and my community are now put on hold. Whether or not my actions of last August define me forever or reset my moral compass are now up to me. I will not let this define me. I accept my punishment, and I'm ready to bring to an end this unfortunate chapter of my life.
George admitted to acting impulsively and without consideration of the consequences, accepting full responsibility for the choices he made. He asked for mercy from Judge.
I humbly ask Your Honor for mercy. Your Honor, as you consider my punishment, I ask for your mercy. The mercy to give me the chance to make a right or wrong, to make right or wrong, and live the life God has chosen for me.
Not only for the individual like yourself to ever do something like this again, but for the community at large to understand that with every action comes a consequence, and people need to be prepared to face consequences if they're going to behave this way. That's called deterrent, the deterrent effect. I'm supposed to balance, and I do balance, the principles of punishment. That is, for every action, there's a consequence, so there needs to be a punishment if it's a negative action. I also balance the principles of rehabilitation and protection of society. All of those weigh into my equation, if you will, in fashioning an appropriate sentence. Let me begin by saying that. I've been a judge for 17 years, and I've seen a lot of different things along the way, Mr. George. People addicted to crimes, people addicted to drugs, people addicted to abuse. And this particular situation you find yourself in, Mr. George, of all the cases I've seen in 17 years, I cannot stop scratching my head. You come to this community with everything on your plate. And one fell swoop, you throw virtually all of it out the window. And there appears to be, on its face, no justification whatsoever for it. Nothing. It is the height of impulsive behavior. And it's inexplicable to me. It really is. As far as any type of incarceration, it is the sentence of this court that you serve no less than 32 months to no more than 120 months with the Michigan Department of Corrections.
The judge, who had presided over numerous cases, was struck by the senselessness of George's actions. They emphasized the importance of holding George accountable while also considering the potential for rehabilitation. Balancing these factors, the court sentenced George to serve between 32 and 120 months in the Michigan Department of Corrections, ensuring both punishment and an opportunity for him to reflect and reform.
The last 9 months have given me an opportunity to reflect on my purpose, my path, and my principles. In returning home to live with my mother and father, I've steered clear of the law and spent my time working at Liberty USA and volunteering at my church, helping other kids like me to avoid similar mistakes. Most importantly, helping them understand how one bad choice can impact their families and their victims forever. When this is over, I plan to resume my studies and earn a degree in business management.
George began his sentence in 2017 and remains incarcerated, with a potential earliest release in 2026. He has expressed intentions to use his time to rebuild his life and guide others to avoid similar mistakes. The victim, meanwhile, continues her journey toward healing, seeking to rebuild the sense of safety and stability she lost that day. Melody Hoffman, a 20-year-old known for her kindness, creativity, and loving nature, suddenly disappeared in early 2024, leaving her family and community deeply worried. McKinley Louisma, who had been staying temporarily at her family's home due to personal challenges, was the last person to see her. Despite the family's efforts to support him, tensions arose due to his failure to respect their boundaries. Melody's mother, Megan Hoffman, became concerned when her daughter did not return home as expected and used a location tracking app to monitor her movements. This tool proved vital, leading to the discovery of Melody's phone, which had been left on a roadside. This discovery raised suspicions and played a key role in the subsequent investigation.
I knew she was with you from the moment she left our home. I knew where she was and what happened to her, even though you told me you didn't. I only ever gave one name to law enforcement personnel during this whole investigation. Your name. I was following her Life 360 location. I knew where she had been, and I found her phone on the side of the road.
The investigation built a strong case against Louisma, using a combination of digital evidence, witness testimonies, and physical findings. Law enforcement uncovered inconsistencies in Louisma's statements and tracked his movements in the hours surrounding Melody's disappearance. This evidence, coupled with Megan Hoffman's early efforts to document Melody's last known whereabouts, became the foundation of the prosecution's argument. Further investigation revealed the involvement of co-defendants Dakota Van Patten and Logan Kimpton, who were charged for their roles in planning aspects of the crime. During the trial, the prosecution presented a detailed narrative supported by forensic evidence and testimony. Investigators explained how Melody's phone, location data, and physical traces at key sites confirmed the timeline of events. Prosecutors highlighted his betrayal of the trust extended to him by a family that had provided him with shelter and support. Witness testimonies from family members provided a glimpse into Melody's character and the devastating impact of her loss.
But no, I will not be sharing how this has impacted me. I will not share the impact of hearing Megan's vehicle say Melody when she calls somebody from the vehicle's UI, because Melody is the first contact and she has not deleted Melody as a contact. I will not share the impact of having to sign her out of my Xbox every time I turn the Xbox on because I use her controller, or the impact of the Xbox saying goodbye Melody as a result of using her controller to sign in. I will not share the impact of knowing her paintings will no longer grace the presence of any material when I see her painted bedroom door, the painted bathroom door, the painting in the living room, or the shed she painted. I will not share the impact of taking 4 months off of work at a career I've had to work hard at. I will not be sharing how this has impacted me because I can't even be honest with the true impact of this. I would be sharing this impact through an experience I don't even understand. You don't know what that means, but that's okay. You don't know what any of this means. I will not be sharing how this has impacted me because that thing will not be able to understand, let alone empathize, sympathize with how this has impacted me. If that thing has the imagination to bring about this reality, then there's no need for me to share this impact, as that thing's imagination could provide that over the next couple lifetimes he spends behind bars. I will not share the impact of having to live in the reality that thing imagined instead of one of the many I imagined. I will not share the impact of deciding to believe in a previously abandoned pantheon just so some solace is gained from knowing that thing will spend an eternity in the lower levels of hell. I will not share the impact of wondering what would have been a child that was yours, as opposed to what the other girlfriend gave you. No, I won't be sharing how this impacted me. There are no sighs, facial expression, words, or any form of communication, new or old, that would be able to accurately capture the impact this has had. No, I will not be sharing how this has impacted me.
Tyler Hoffman, Melody's brother, delivered a moving victim impact statement describing the profound emptiness left in their lives and the everyday reminders of her absence, such as her unfinished artwork. He explained how these reminders amplified the family's grief and underlined the severity of the loss.
I know Melody would want me to forgive you, but I'm not sure that'll ever happen. And if it does, it's only for her, not you. You have taken so much from me, my family, friends, and even complete strangers that have reached out. Melody will live forever in each and every one of us. She will be remembered for the kind, caring, loving, organized, silly, artistic, music-loving, slime-making, selfie-taking, video-making, supper-cooking, animal-loving girl we all remember. I've even learned that she will even be a part of future generations of Iowa law enforcement education, continuing to teach about technology and how everyday people can use it to benefit their lives, and how law enforcement can use it to help solve crimes that will put criminals like you away where they belong, and hopefully bring some justice to families of these vicious, sinful, vile malicious, evil, villainous crimes. I'm sure her Wednesday morning coffee boys, retired law enforcement agents, are ecstatic to hear this. Justice will be served to those who deserve it, to its fullest here on earth. A much higher power will get the final justice. I have no doubt when your time comes, you will not be allowed in the same place we all know Melody is now, with her sister and our only grandchild, safe and far away from everything evil. I will fight every day to keep her memory alive and strong, and let her live on as long as I can through me. I know I'm not the only one determined to do this. So, from all of her loved ones, we all wish you the life that you deserve until you take your last breath. When I first met you, I only asked 3 things of you. Don't lie to me. You have multiple times, but I see through them. Don't bring your gun into my home. You did, and I kicked you out. Respect everyone and take care of each other. This one for you and Mel. She always cared for you. However, you did not respect or care for her, or you wouldn't have done this or allowed this to happen. Therefore, you have broken every single one of my rules. You f***ed with the wrong mama. You messed with the wrong family. I'm sorry you never felt like you fit in to our family. I now know you could never fit into a caring, loving, supportive family. I'm sorry you never experienced a family with such strong characteristics. In fact, I don't see any of your relatives here supporting you today. Maybe the issue is you, and not the rest of us. I know at one time you asked her, "Are you scared of me now?" And to that I ask you, are you scared of her now? Are you scared of me now? Now that your only view will be obstructed by bars for the rest of your life.
Megan Hoffman's testimony was particularly impactful. Addressing Louisma directly, she spoke of Melody's kindness and generosity, contrasting it with his betrayal of their family's trust. She shared how her daughter had consistently supported Louisma, even convincing her family to offer him shelter. Megan vowed to keep Melody's memory alive and expressed her determination to see justice served. Her raw and heartfelt statement underscored the emotional toll the crime had on the family and became a pivotal moment in the courtroom. The trial took place in late 2024 and featured detailed evidence of Louisma's actions and their impact on Melody's family. Prosecutors highlighted his betrayal of the trust extended to him by a family that had provided him with shelter and support.
So the sentence in this case for murder in the first degree, kidnapping in the first degree, are each mandatory sentences of life in prison. That's the sentence the court will be imposing. While those sentences are mandatory, those are also the sentences that the court finds to be appropriate for these very violent, cruel, and completely senseless acts. Sir, your offenses are obviously devastating to Melody Hoffman's family, but they also undercut really the safety and feelings of security for the entire community. A sentence of life in prison with no possibility of parole is the appropriate sentence for these crimes, and they're necessary for the protection of the community. The maximum sentence for the offense of conspiracy to commit a forcible felony is a 10-year indeterminate prison term. While it's largely symbolic in this case, given the sentences of life in prison, for the other offenses, the court finds that the maximum sentence of 10-year indeterminate term is the appropriate sentence based on the level of planning involved and the fact that the forcible felony involved is a Class A felony. So at this time, the court adjudicates defendant to be guilty of the offense of murder in the first degree in violation of Iowa Code Sections 707.1 and 707.21b. And as a sanction for this offense, a defendant is committed to the custody of the director of the Iowa Department of Corrections for the rest of his life. The court further adjudicates defendant to be guilty of the offense of kidnapping in the first degree in violation of Iowa Code Sections 710.1 and 710.2, and as a sanction for this offense, defendant is committed to the custody of the Director of the Iowa Department of Corrections for the rest of his life. As to each of these offenses, the defendant shall not be released on parole unless the governor later commutes the sentence to a term of years. The court further adjudicates defendant to be guilty of the offense of conspiracy to commit a forcible felony in violation of Iowa Code Sections 706.1b and 706.31. And as a sanction for this offense, defendant is committed to the custody of the Director of the Department of Corrections for an indeterminate term not to exceed 10 years in order to pay a fine in the amount of $1,370. Defendant is given credit for all qualifying time previously served on this offense, and the terms of incarceration as to this offense only may be reduced because of good time work credits and program credits, and defendant may be eligible for parole before sentence is discharged. The sentences shall run concurrently to each other. Temporary custody is placed with the sheriff pending transfer to the DOC. Pursuant to Section 910.3b, defendant shall pay restitution in the amount of $150,000 to the estate of Melody Hoffman if an estate exists, and if no estate exists, to Melody Hoffman's heirs at law.
On November 14, 2024, the jury found Louisma guilty of all charges, including first-degree murder, first-degree kidnapping, and conspiracy to commit a forcible felony. His sentencing, originally scheduled for December 6th, was postponed to December 20th to accommodate the family's availability. The court handed Louisma life imprisonment without the possibility of parole for the charges of murder and kidnapping. An additional 10-year indeterminate sentence was imposed for the conspiracy charge, recognizing the planning involved. The court also ordered him to pay $150,000 in restitution to Melody's estate or heirs, acknowledging the profound loss suffered by her family. Legal proceedings for the co-defendants are ongoing. Dakota Van Patten is scheduled to stand trial in March 2025, while Logan Kimpton is set for trial in April 2025 for conspiracy charges. These proceedings will further address the roles of the individuals involved in the crime. Myon Burrell's legal journey is a story of second chances and ongoing challenges. In 2002, Burrell was convicted for the tragic death of Tyesha Edwards, who was killed by a stray bullet in Minneapolis. Burrell was sentenced to life in prison, though he maintained his innocence throughout. Over the years, concerns were raised about the evidence used in his conviction, leading to increased public scrutiny. In December 2020, after nearly 2 decades behind bars, Burrell's life sentence was commuted by the Minnesota Board of Pardons. This decision was based on a review of his case, which highlighted potential flaws in the original investigation. Although he was released, Burrell's conviction was not overturned, and he remained under supervised release. His commutation sparked discussions about systemic issues in the justice system and the challenges of reintegration for those who have served lengthy prison sentences. In August 2023, Burrell was arrested during a traffic stop in Robbinsdale, Minnesota. During the stop, law enforcement reported finding a firearm and substances suspected to be drugs in his vehicle. As a convicted felon, Burrell was legally prohibited from possessing a firearm. This arrest led to charges of illegal firearm possession and drug-related offenses, raising questions about his activities since his release. Legal proceedings began in 2024, with both the defense and prosecution presenting compelling arguments.
I don't think the court will be surprised to learn that my concerns are primarily focused on the issue of public safety, as I believe they echo a few of your concerns that you mentioned during sentencing, Judge. We had as I think you referred to it as something, somewhat of a gift in a commutation of sentence in 2020 and a release from supervised release in 2022. And then this incident happened in August of 2023. And at that time, Mr. Burrell was aware that he had not been pardoned, his sentence had been commuted, and he was prohibited from having any gun, let alone that gun, with an extended magazine and multiple rounds of ammunition. So that, of course, is one concern for safety and the primary issue with this case. But while resolution of this case was going through the court system, Mr. Burrell picked up another case that is pending where he was found in possession of a pill in his vehicle. A search warrant was executed. Took him a long time to open up the car doors, and in the squad video there's appearance of trying to hide something during his detention in that matter. That's of concern to the state that happened, and certainly a new charge has been issued and that case is still pending. Also of significant concern, Your Honor, is the fact that after the court found Mr. Burrell guilty of this very serious offense with this firearm and these drugs in his car, and again, I think you clarified this on the record, Mr. Applebaum, I believe, said that the firearm was in a backpack out of reach in the pleadings, but that's not true. That firearm was found in the center console, and I know you watched the body-worn camera of that, so it was accessible. But after all of that, and after your determinations of Mr. Burrell's guilt, he was then found in a Burnsville parking lot on September 9th, having just ran into another vehicle, and with a .06 blood alcohol concentration and an open container of cannabis in the car. And that was even after the finding of guilt. As the court is well aware, I did ask the court to hear the state on conditions of release because of those public safety concerns that were ongoing. I understand from Ms. Neubauer that once the court did place him on EHM, as you did after that hearing, that he's done better. But that's been since October. This case has been going on since August of 2023. So I think the state's biggest concerns here, Judge, as you consider this application for release pending appeal, is the safety issue and the ongoing conduct while this case was pending, in addition to just this case existing in the first place. So the state does oppose the application for release pending appeal, and I appreciate the opportunity to make that record.
The prosecution expressed concerns about public safety, citing the nature of the new charges and Burrell's behavior while on release. They pointed to the evidence from the traffic stop as well as additional pending charges, arguing that these incidents reflected a troubling pattern. They urged the court to prioritize community safety in its decision.
Only that if I implied or outright stated that it was the state's burden that there's no likelihood of serious crime or intimidating witnesses, I apologize for that. I meant that
The court has to make those findings, and I don't think that the court can do that. I think that this Burnsville case is a tempest in a teapot. It was a payable offense. He could have gone down and saw a hearing officer and gotten rid of it. So he's not even been convicted of that. So I don't even know how that's relevant to anything. And there's a motion to dismiss pending on that situation. I don't think that that's relevant. I think that the people that spoke on Myon's behalf were incredibly eloquent and acknowledging that he didn't but now does have a safety net. And I'll say it for the fifth time. I think this is an easy call, Your Honor. And if I'm all wrong about Myon and what his mental state is now, you can issue a warrant, yank him back in, and he goes straight to prison. So I just think there's no downside to doing this. And I won't just circle back and start repeating myself again. I think it's all been clear. And these witnesses were amazing. And I hope that you take what they say to heart.
Burrell's defense team, however, emphasized his efforts to rehabilitate and contribute positively to the community since his release. They presented letters from community members and employers attesting to his character and work ethic. Supporters spoke passionately about his involvement in mentoring at-risk youth and his dedication to supporting his family. The defense requested leniency and a stay of sentence pending appeal, arguing that Burrell had made significant strides toward rebuilding his life.
The community and supporters of Mr. Burrell, many of whom have been at other hearings here, and clearly he has made an impact in the community, and as I noted during my earlier remarks, continues to make an impact in the community with young people in particular, and to me that's quite impressive, and I acknowledge that, and I appreciate everyone here who's here and everyone here who came up to speak, and I know that's not easy. And you do it because you care about Mr. Burrell and care about the community at large.
The judge carefully reviewed the evidence, weighing the defense's argument about Mr. Burrell's rehabilitation and community support against the prosecution's concerns about public safety and ongoing legal issues.
It actually reads, a court must not grant release pending appeal from a judgment of conviction unless the defendant establishes to the court's satisfaction, 1, the appeal is not frivolous or taken for delay, and no substantial risk exists that the defendant will fail to appear to answer the judgment following the conclusion of the appellate proceedings, and is likely to commit a serious crime, intimidate witnesses, or otherwise interfere with administration of justice. That's right from the rule itself. So let me deal with each of the parts of that rule separately. The appeal is not frivolous. That's an easy question for me to answer, and it's certainly not taken for delay. Another judge of this court presided over the suppression hearing in this case, over a contested evidentiary hearing on the defense motion to suppress the evidence back in February of this year, and the judge issued an order on April 29, 2024, denying the defense motion to suppress. I find that the legal issues raised by the defense regarding the expansion of the stop after the police stopped Mr. Burrell's vehicle on August 29th for several traffic violations, field sobriety testing, and his arrest and the subsequent search of the vehicle are not frivolous. And they're not subject to taken for the purpose of delay. So let's just put that aside to start with. So that condition is certainly not applicable. Then the next question is whether there's substantial risk that the defendant would fail to appear following a judgment after the appellate proceedings are concluded. Mr. Burrell's appeared for every hearing. I placed him in EHM. He has largely complied with EHM, as I understand from Ms. Newbar. Of course, now you are convicted of this offense of the prohibited person possession of a firearm, and I've ordered you to serve 60 months in prison. That changes the equation a bit, but I don't necessarily see that you wouldn't appear following a judgment of the appellate court, so I don't think that is necessarily applicable. The other question is whether you would commit a serious crime, intimidate witnesses, or otherwise interfere with administration of justice. Let me just address intimidate witnesses or otherwise interfere with the administration of justice. I don't think those are applicable here. I've seen no evidence of that. So in my view, the critical issue, and many of the witnesses who just testified before me spoke to this issue, is whether there is a substantial risk that Mr. Burrell is likely to commit a serious crime if he's released pending appeal. And the key question then is for me to assess whether the defendant has established to me, this court, to my satisfaction, that there's no substantial risk of the likelihood of committing a serious crime. So let's run through where the record stands. Again, applying the record before me as objectively and fairly as I can. The first case is the case you're here before me on. You've now been convicted of 2 very serious criminal offenses, the first of which is the possessing a Glock 9mm handgun with an extended magazine clip with 19 bullets in your automobile. And our community wrestles every day with the proliferation of firearms. And I believe, Mr. Edmund, you spoke to that issue and how these firearms cause so much damage in our community. In addition, it wasn't just the firearm. You also had 37 meth and MDM pills. And this occurred less than 3 years after you were released from prison. These are certainly serious crimes. I've spoken to that. There's no question in my mind they're serious crimes. And you've been convicted of both of those offenses. I believe that is evidence in this. I find that it supports evidence that you may be a substantial risk for committing future serious crime.
In December 2024, the court sentenced Burrell to 60 months in prison for illegal firearm possession and an additional 19 months for drug possession. with the sentences to run concurrently. During the sentencing, the judge emphasized the seriousness of the charges and the need to enforce accountability. The court also denied Burrell's request for release pending appeal, citing concerns about the risks associated with his release and the pattern of behavior observed. Burrell's defense team is appealing the legality of the traffic stop, which they argue may have been improper. While the appeal is ongoing, Burrell has begun serving his sentence. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.